we learned a little bit about negligence earlier in the book when we were talking about torts. The difference when it comes to negligence theory as it relates to product liability is that there's a couple of other things that you have to prove. If you remember with negligence, there's the whole issue of you have to prove that there was a duty of care, and then the duty of care was breached, and then that breach of duty was the proximate cause of the injury. That's the basics of negligence, of a negligence tort. When we're talking about negligence as it relates to products, it's those same things, but a couple of other things. The first of which is this: that you have to prove that somebody sold a product to you. If again, you can't really sue somebody for product liability if there was no merchant transaction. So if somebody just gave you a product and it was faulty, you can't really hit them with a product liability suit. And then the other thing is it's very hard to say, well, what was the duty of care that the manufacturer breached? If the manufacturer did everything right, even then sometimes some products are faulty. So negligence theory is sometimes hard to use when dealing with product liability. That being said, sometimes you can prove that there was a breach of duty. A good example of this would be when the people were suing, the state attorney generals were suing the cigarette manufacturers. You could argue that people knew cigarettes were bad for them, but when they were able to unearth information that said cigarette manufacturers knew years before the general public knew that cigarettes were bad for people, and then they hid that information and even put more ingredients into cigarettes to make them more more likely to get people addicted, then you start to say they breached some duty, right? Well, we do have a duty to safely manufacture our product and make sure it's fit for its intended purpose. We also have a duty to not purposely harm people. And so that's when a situation like that is where you can actually say there was a duty and they breached that duty. Proximate cause is also difficult to prove. How do you prove that it was the cause of this product as opposed to something else? Also, contributory or comparative negligence, right? If somebody's using the product in an inappropriate way and then it harms them, is that really the manufacturer's fault? I know some kids who threw a can of spray paint into a campfire, and the can of spray paint exploded and burned one of the kids very badly. Is that the manufacturer's fault? Or is there a comparative negligence going on there? And then related to that would be any alteration of the product. Sometimes people buy something from a manufacturer, think of cars as an example, they alter it, maybe they put aftermarket rims or they lift a lift kit or something on it, and then they have problems with it, and maybe something fails in the car and they're injured, and they want to sue the manufacturer might be able to come back and say, no, you altered the car. And so that's not our fault. It's your alterations that were the proximate cause of your injury. Anyway, there's a couple others on there as well, but I think you can read them, like I said. The important thing to remember is negligence theory is challenging when you're trying to sue somebody in a product liability case. And likewise, if you're the business owner, which I know many of you will be someday, it can be an easier way to defend yourself if they're working off of negligence theory. A little harder if you breached those basic warranties that are provided for in the code. So in other words, if you want to be safe as a business owner, just ensure that you warrant your product appropriately. Don't make promises that you can't keep. And if people have problems with the product, do your duty by them. And that's going to protect you from liability in most cases. And then remember, if somebody does sue you, that they're going to have a tough time proving negligence unless you've done something really extreme, like hide the fact that your product was dangerous and you knew it all along. Those are the people that get sued and probably should get sued under negligence theory and in the way in the common law system, the way it currently works.